Okay, morning everybody. Raghav and I are going to talk to you this morning about injunctions. I'm just going to share the slides with you, if you just bear with me one moment. The idea of the talk is that it's not going to be in-depth into one particular type of injunction. What we're going to try and do this morning is go across the breadth of the practice procedure, any hints and tips that we can think of that might be useful. And as I say, it's going to be quite broad, but hopefully enough information there to assist you. As usual with these webinars, if you have any questions or queries, then you can email Raghav and myself at the end, and the webinar itself and the slides will be made available afterwards. I am in charge of the slides for both Raghav and myself. So it might be a bit like a Downing Street press briefing where Raghav asked me for the next slide, please. But bear with us and we'll get you through this. Hopefully we'll be about half an hour. As I say, there's a lot to cram into this session. So if we go slightly over, please do excuse us. But as I say, we will do our very best to be done within half an hour. Okay, so what are we going to talk about? Just a bit of a roadmap to this session, really. Raghav's going to take you through the types of injunctions. Together, Raghav and I will then talk about general procedure, evidence and legal principles. Raghav will then talk to you about without notice applications and the particular procedure and requirements from the applicant. I'm then going to talk to you about the return date and with notice applications, and together we'll give you any practical tips and tactics that we can think of along the way. So over to Raghav.
Thank you, Kirsty. So as Kirsty has mentioned, the topic of injunctions is quite a broad topic. So we thought it best to set out in diagram form an overview of the types of injunctions and the terminology that is often encountered in practice. I don't intend to go through each type of injunction that's on the screen in front of you. And of course, the webinar will be uploaded on Chamber's website and on LinkedIn in due course. But broadly speaking, you'll be aware that injunctions are broken into prohibitory and mandatory, interim and final. Final injunction is one that is sought as a final remedy at trial. Just two key points that I would like to address you on at this stage is under the heading of search orders, and in particular when considering the insolvency setting, is section 365 of the Insolvency Act, which talks about search and seizure order applications, and a recent authority of Latvia and Kumatu, which has provided guiding principles in relation to those applications and how to draft an order at a without notice hearing in relation to the same. So that's worth bearing in mind in respect of those types of applications. And also under the heading of proprietary injunctions, there's the seminal authority now of AA and persons unknown, which considers cryptocurrency and crypto assets and has determined that those are forms of property in law and can be the subject of a proprietary injunction. For the purpose of this webinar, as Kirsty has explained, our focus is upon interim injunctions for the very reason that we only have half an hour, and so that provides some substance to this webinar as opposed to superficially just going through the various types of injunctions. So the fundamentals is what we're concerned with here in respect of interim injunctions. One particular point to note is Rule 25.14, which is on the screen in front of you, where the court may grant an interim remedy whether or not there's been a claim for a final remedy of that kind. So essentially, you don't have to have made a claim for a final injunction in your claim form before making an application for an interim injunction. So if we can move on, Kirsty, to the next slide. So in terms of the general procedure and evidence applicable to applications for interim injunctions, the practitioner must bear in mind that there are two aspects of the CPR that must be considered, and that's Part 25 in conjunction with Part 23, which talks about the general procedure for applications. The form that must be used when making an application, as you may be aware, is Form N244, more generally speaking. But if you are in the county court, there is Form N16A, which is available as well. Kirsty will come on to discussing the legal principles in a moment, but it's safe to say that, as what's set out at the top of the screen, the court may grant an interim injunction, so the court does have a wide discretion in relation to the same. The scope when making an application for an interim remedy more generally set out in Rule 25.21. In essence, an interim remedy may be made at any time, whether that's before proceedings are started or after judgment has been given, for example, as an aid to enforcement. But the rule itself has some caveats. Essentially, if there's any rule, practice, direction, or other enactment which provides otherwise, then that particular provision won't apply. And if an interim remedy is granted before a claim has been commenced, that can only happen where the matter is urgent or is otherwise desirable to do so in the interests of justice. And if you are a defendant making an application for an interim injunction or any of those interim remedies, then you can only do so where there's an acknowledgement of service or a defense that has been filed. What is crucial, as set out at the bottom of the screen in front of you, is that an application for an interim injunction must be supported by evidence, whether that's in the form of a witness statement, a statement of case, or an application notice verified by a statement of truth. And that evidence must set out all material facts of which the court should be made aware, which makes clear that there is a blanket requirement. And whilst I'll touch upon the duty of full and frank disclosure when considering without notice applications, there is a blanket requirement that the evidence must present everything that is material to that application. So Kirsty, you can go on to discuss the legal principles.
Thank you. So where does the power come from? Well, Section 37 of the Senior Courts Act 1981 provides that the High Court may grant an interim or a final injunction where it is just and convenient to do so. And those are the key words, just and convenient. Those orders may be unconditional or they may be conditional, which we'll come on to in a little bit more detail when we talk about orders in a few moments. And that has been confirmed in the case of Forey and LaRue. If the court doesn't grant an injunction, as Raghav has already mentioned, it's the court's discretion. So it's the court has refused to exercise its discretion if they decide that actually, no, this isn't a case where an injunction is warranted. And the key thing and the thing that's set out in Section 37 is that if you're making your interim injunction before proceedings have begun, then it's presupposing the existence of a cause of action. So the court really does examine quite carefully the evidence that you're putting forward, as they do in any case, but in particular where the action hasn't yet started. And we'll talk about that in a little bit more detail in a few minutes. And Section 38 of the County Courts Act 1984 allows the county court to make injunctions in cases that are brought in the county court as the High Court would. There are some exceptions, but they're not. We won't go into those in too much detail right now, otherwise we'll run out of time. As I'm sure many of you are familiar with, the test that the court applies is the American cyanamide principles. So just very quickly, is there a serious issue to be tried? Or are damages an adequate remedy? And where does the balance of convenience lie? In the case of American cyanamide, Lord Diplock set out 12 principles which he was looking at when he was going through these questions, and those principles are what people examine when looking at these three particular questions. The most important when looking at the first question, is there a serious question to be tried, is the court is looking at if the alleged wrong has been committed, has it violated the applicant's legal rights? And is it satisfied that the claim isn't vexatious or frivolous? So you've got to overcome those hurdles when you're putting your evidence forward, clearly set out in your evidence these points. It may be that your witness statement adopts these three approaches and answers these questions. Or it may be that you just leave that to the skeleton argument and counsel does that for you. In terms of looking at would damages be an adequate remedy, the court also looks at the position of would the defendant be in a position to pay those damages if damages were to be considered. So if you're making an application against another company, for example, you might go and look at their last filed accounts. Is there anything worrying in there that you need to point out in your evidence? And then there's also the cross-undertaking and damages that needs to be considered at this point, which we'll go into in a little bit more detail. But basically, if the defendant was successful at a final trial, is the claimant able to compensate them for any costs that they've incurred? When looking at this element, the court also goes on to look at the balance of convenience. So if it's finely balanced, the court will always look to preserve the status quo. So, for example, if you have an injunction where somebody has taken a particular piece of confidential information, then it may be that the status quo there lies in favour of the applicant because it's their confidential information, although it's not yet been proven, but they're preserving that position of the applicant. And as I say, the cross-undertaking as to damages, that comes from Practice Direction 25A, 5.2. So you might be asked, or it might be sensible, if you're a company, to provide your last filed accounts to demonstrate that you're in a strong financial position to be able to compensate the defendant in damages. What happens normally, if you haven't addressed that point in your application, is, particularly if you've gone without notice, the respondent's legal team will attack you on that point, and they'll go and start looking at your accounts, and if they can say, well, you're not in a position actually to adequately compensate us. So just bear that in mind when you're preparing your application. I'm going to hand back over to Raghav now to talk to you about without notice.
So when considering without notice applications, the threshold question for the court to answer is whether or not there are good reasons for giving notice. And that must, of course, be addressed in the evidence itself. The test for that comes from the case of National Commercial Bank Jamaica Limited and Olent Corporation, the third bullet point on the screen. And the question to be asked is whether or not giving notice would enable the respondent to take steps to defeat the purpose of the injunction. So that's a question of secrecy, or whether there has literally been no time to give notice before the injunction is required to prevent the threatened wrongful act, i.e. a question of urgency. Without notice applications are generally an exception to the general rule that notice should be given for a party to be given an opportunity to be heard before an order of the court is made, as a basic principle of fairness. So, of course, those two categories exist before the court will even consider making an interim remedy or interim order at without notice application hearing. Of course, the second category of urgency is quite a rare one nowadays, given the fact that we have access to mobile phones and telephones, emails, and the internet more generally, such that informal or short notice can be given. But as stated, the key thing here is for the evidence to make it clear what category the case falls into, to persuade the court that an interim remedy or an interim injunction in this case should be made without notice to the other side. At the bottom of the screen, I've highlighted the practice direction to part 25, paragraphs 4.1 to 4.5. I don't intend to go into that at this stage. It's self-explanatory in terms of the procedural requirements for a without notice application, namely what must be filed and served before, at the time an application is made, filed at the time an application is made, and what must be served with an order after the hearing itself. Kirsty, if you may turn to the next slide. What is of utmost importance at an application made without notice is the duty of full and frank disclosure. Now, this is summed up very well, in my view, in the case of Memory Corporation and SIDU, as a high duty requiring the applicant to make full, fair, and accurate disclosure of material and significant information which relates to factual, legal, and procedural aspects of the case. I would say that that quote is worth remembering and taking with you at any time when an application for an interim injunction is made and there's a without notice hearing, because that really tells you what must be included within the evidence. Namely, the information must be material, and that's objectively
We are just having a few technical difficulties. If you just bear with me one moment. Raghav seems to have dropped off. So if I continue, can you all still hear me? Can I just have a couple of you just raise a hand just to show that, yeah, brilliant, thank you. Okay, so I will just, thank you, everyone seems to, that's great, thank you so much. I will just pick up on duty of full and frank disclosure for Raghav, and hopefully he can join us again in a few moments. I think Raghav had gone through very well the statements in Sidhu. So really it's about, is this a continuing duty? Here he is back. So a continuing duty, Raghav, you were just about to pick up there. I was just about to take over, but if you're ready, or you seem to have frozen again.
That's perfectly fine.
Brilliant.
No,
Well, Raghav, you're a bit jumpy. I'll continue with a continuing duty, and if you become a bit more stable, then I'll hand back. So a continuing.
Can you hear me? Brilliant. I think there's been a power cut in the local area, so everything.
Raghav, it's not great. So a continuing duty. The duty does not cease upon making the order sought at a without notice hearing. So if no new circumstances come to light, then it's for you to disclose those between the order and service, and that is, as I say, a continuing duty. It doesn't, just because I've served this, doesn't mean that your duty of full and frank disclosure then completely drops off. Also, think about, can you be attacked for a material non-disclosure? So for, as I say, what you should be disclosing is everything that assists your case and anything that doesn't assist your case. Normally what you'll find, particularly on the return date, is that the respondent is saying, well, there's been a material non-disclosure of these particular facts. And they might pull out 2 or 3 emails, for example, that they say you haven't disclosed, which provide an alternative or an alternative story, for example. Now, I'll just come on to that in the returning duty and what the court has to look at there. But if there has been a material non-disclosure, then the court can discharge the injunction. But it then also has the option and the discretion to allow or reinstate the injunction again after that material non-disclosure. Raghav, you've come back and you're a bit stable, so do you want to pick up shorter informal notice?
Yeah, that's perfectly fine. I do apologise for that. I believe there was a power cut in the area and everything just shut down and then started back up, so I lost Wi-Fi and everything.
No problem, you're back now.
Excellent. So are we on short and informal notice, did you say?
Yeah, we are.
Excellent. So just to summarise everything that's been said up until this point. So in terms of shorter informal notice, the key point there is that the duty of full and frank disclosure is not absolved. It still exists at that point in time. So if you do have the other side in attendance, the reason why that duty exists at that point is because they've not had the chance to properly prepare for the application. What's important to note is that duplicative information does not need to be presented to the court. So if there's something the other side have mentioned, which you feel would have been important to mention if they weren't in attendance at a without notice hearing, you don't need to repeat that or stress the importance of that to the court. In respect to the duty of full and frank disclosure altogether, there's a key case of Tugashev and Orlov, which in essence summarizes everything you need to know about this duty, from the duty itself, applications for material non-disclosure, and the consequences of breach of the duty itself as well. It's considered in the context of freezing injunctions, but it's relevant across the board. And one point to bear in mind is, the judge stated that an applicant must make proper inquiries before making the application, and that he must investigate the cause of action asserted and the facts relied on before identifying and addressing any likely defenses, and that no amount of urgency or practical difficulty can justify a failure to identify the relevant cause of action and principal facts to be relied on. As you'll see from the screen, I've said that the importance of this is prep, prep, prep. One must lay down the foundations for an application before it is made, and set out all the relevant evidence to show why notice could not be given and that the duty of full and frank disclosure has been complied with. And what's important is, no matter how urgent your application may be and how hastily produced it may be, the duty of full and frank disclosure is still considered by the court to be of utmost importance. So it doesn't matter even if you feel you haven't provided all, or you're not sure whether it's material or not. It may be important to include it in any event to avoid the consequences of breaching this duty. If you can move on to the next slide, Kirsty. At a without notice hearing, what's also important is to make sure that you have a contemporaneous note going of what's going on in that hearing, so that submissions made by counsel and any points or queries that have been raised by the judge, because that has to be served on the other side after the hearing. Now, in my view, this doesn't have to be verbatim. It can be shorthand, as long as all the relevant points that the court has raised and all the submissions are within that note. The commentary in the White Book makes clear at 25.3.10 that a failure to provide a note to the other side may result in an award of indemnity costs in favor of the party affected. And so that shows the importance of complying with this duty. And that's a duty upon the legal representatives, including counsel. I've also made a note of the practice direction again to part 25, paragraphs 5.1 through to 5.5, which sets out the relevant requirements to be included in the draft of the order and any undertakings that the applicant has to produce. Now, I don't intend again to go through those, and they are self-explanatory. They deal with things like the return date to be included within the order. But what is of importance is subparagraph 5.5, which says that any order for an injunction must set out clearly what the respondent must or must not do. So that makes very clear that the terms of the injunction must be as precise as possible. And if it isn't precise, then there may be issues in terms of enforceability. Kirsty, if you can move on to the next slide.
Okay, so the return date then. Technically, this is the date on which the injunction will cease unless there's a further order of the court. Now, the court is looking for a short return date, usually a week to 2 weeks. I have been in situations where judges in Birmingham have said to me 3 days, and I said, well, actually, no, that's not appropriate. And this point about timing is, you as a legal team, when the judge is offering you dates, think about how much evidence are we giving to the other side, particularly, you've gone without notice. Are you giving them a small ring binder of evidence, or are you giving them 2 lever archfuls of evidence? You need to think about, is this person even going to have the slightest inclination that anything is coming? Because they're going to have to instruct solicitors. And you need to think about all of this when you're thinking about those dates that the judge is offering you. If you've got a small ring binder, then there's nothing wrong with a week, for example. If you've got a lever arch full or 2 lever arch full of documents, then I suggest that actually a longer date might be more appropriate. Now, this ties into the second point on this slide of adjournments. If you go too quickly with the return date, what's more likely than not to happen is that the other side will be seeking an adjournment. You may attend on the return date, and the other side says, well, look, we haven't had the opportunity to properly go through this, put our evidence in reply, which we're entitled to do, and therefore we seek an adjournment. The consequence of that is obviously costs are increased for everybody, and it could be something that's avoided if at the without notice hearing, you just say to the judge, actually, is there something a little bit further down the line that we can have in terms of a return date? As the applicant, you know, it doesn't prejudice us in any particular way if we go for 2 weeks. We understand our duty to the other side, and that there's, you know, something they're prohibited from doing something at this moment in time, particularly with freezing orders. They are very draconian, but actually, if the respondent is right and in 2 weeks it's discharged, well, there's this cross undertaking and damages which is going to protect them. So it's all about formulating those arguments, really. At the return date, it's important to remember that this isn't a mini trial. The court cannot come to conclusions of fact at this return hearing. Some judges might stray into that territory, and if you're the respondent particularly, you might be inviting the judge to do that. But actually, it's not their duty to do that at that time. What the judge is looking at is basically the competing elements, and is it probable, as I said earlier, if it's probable that something is proven correctly, has it impinged the applicant's legal rights? So just think about that. Are you in a strong position to put evidence forward that is monumentally different and shows that actually the case that was presented by the applicants is entirely wrong when you look at all these other facts? Usually this argument ties in with an argument of material non-disclosure. And the material non-disclosure is not going around picking up particular points that you say, oh, look at this one email that hasn't been disclosed. This shows that actually you haven't been told the whole story. Actually, the courts will not allow you to just nitpick, if I can use that phrase. Well, there's an email on such and such a date, there's an email on such and such a date. The key is material non-disclosure. There has to be almost a wholesale case that's just not been put forward in the applicant's evidence in order to be successful on material non-disclosure. And if you, as I say, go along and nitpick, again, you put your client at the risk of costs in that respect. And because you may be considered to be conducting the litigation disproportionately in just trying in any which way to contest this application. Pick your moment. Have you got a strong case? Also, rather than going forward and allowing an injunction to continue, can you say, well, we'll offer you an undertaking, and these are the terms of the undertaking that we're prepared to offer you going forward. Again, that might feature in an order which has a penal notice, but if you as the respondent are saying, well, we'll offer you this undertaking, tactically that could be really good for you. You could be showing, well, we've got nothing to be concerned about, so here's our undertaking that we're willing to give you. So it's worth considering with your clients the tactical advantage of not competing. So we've touched briefly on with notice applications already. Raghav has mentioned that CPR 25 goes hand in hand with CPR 23. And the basic principle under CPR 23.4 is that application should be on notice unless there's a very good reason not to do so. Now, this first point, has your correspondence put the other side on notice? So you may or you may not have corresponded with the respondent up to the date of the application. If you're going to go without notice, one thing to properly consider is, have you at any point indicated in any of the correspondence that you might be going for an injunction? If so, there are cases where your correspondence has put the other side on notice already. And the judges have said, well, you've come for a without notice application, and actually you should be here on a with notice application. You've already indicated to the other side that this was in your contemplation, and it is in fact what you've gone on to do. So you should be here on a with notice application. It's worth thinking about your level of disclosure. If you've gone on a with notice application, you don't have the duty of full and frank disclosure in the way you do with a without notice application, but you still must present your case fairly and consistently. So that is, if there are points that perhaps don't support your case, talk about them. Talk about them briefly, get them head on and say, the respondent may say this, but actually we say this is what it says. Don't hide away from those difficult points just because you're on a with notice application. Also, precision in what you're asking for. Again, just because the other side is there doesn't mean that you can be a little bit more woolly. Be precise in the injunction that you're asking for. Be precise in your evidence. The court is more likely to grant you something where you can be precise and say the reasons why you need it, and you can point out the evidence that is clear and concise in support of that. And again, it's a point for with notice and without notice applications, and Raghav has touched on it very briefly already, is that your order should be in precise terms. State exactly what you're asking for. Anything that's woolly or ambiguous gives the other side the opportunity to say, well, this is harder to enforce, or I don't know what I meant to be doing, because this order has been drafted so widely that one of two things could apply to me, and I went for option 2 over option 1, and the other side says, well, what I meant was option 1. So just think about that neat drafting at that early stage. And also with notice applications, it's something we've touched on again. Have you asked the other side for an undertaking already? If you're going with a with notice application, then it's highly likely you've discussed what you think are the wrongs that the other side have committed. Have you asked them for an undertaking? And if you're the respondent and you've said no, you better have a good reason for why you've said no to that undertaking. Is it because your case fundamentally disagrees? Is it because you say, actually, we don't have the particular documents that you're asking me for, if it's a search order, for example? So just have very clear reasons as to why an undertaking has not been offered or asked for previously if you're going on a with notice application. And just drawing things to a close, so there's some practical tips and tactics that Raghav and I just wanted to just highlight throughout. The key point that I think for both with and without notice applications is just disclose in a fair way. It's not a data dump, particularly without notices. You might have had a whole host of information come in very quickly. So for example, if you have a restraint of trade injunction where you've got a key employee who you think has gone away and taken a load of information, what you might do is download their emails or download their working drive just to see what they've been up to. Don't disclose that whole data dump. Don't pick out the emails that you consider prove a case one way or the other, and disclose them logically and fairly in your witness statement. This second point, consider your remedies early. If you're going for an interim injunction, particularly before you've issued proceedings, get your counsel on board early. Talk about what your case might be. This is what we found with our clients. This is what we think. What are our remedies? Where can we go with this? This then frames your injunction and the order that you're asking for, and the reasons why. Also, you've got a duty to draft your particulars. Normally the order will say, if you haven't provided a draft set of particulars with your without notice application, By the time you get to the return date, the other side is kicking off your particulars of claim anyway, and the order from the return date is going to specify when your particulars should be drafted by. If you've considered your remedies earlier, then it's much easier to draft those particulars of claim, and it's something that can be going on after the first hearing whilst you're waiting for the other side to respond.
In respect of the third point, so you may be in a situation where a respondent may not be able to take steps to defeat the injunction, but you feel that it's urgent enough to make a hastily produced application to prevent a threatened act. But simply stating the reasons why notice was not given and then failing to provide key details showing why notice could have been given may be seen as material non-disclosure. So it may be important to consider whether in fact there was enough time to inform the other side, whether there was a quick method available to informally tell them, even if they weren't able to attend the actual hearing, whether you're in communication with them beforehand, or whether in fact they expected you to make an application at some point in time. This may be information which you may need to inform the court of at a without notice hearing. Further to that, the way in which you present your evidence is crucial when there are other connected matters involving that same respondent. You may be worried that you may tip the respondent off in respect of other types of applications or orders which have been made which have not yet been executed. So other forms of interim remedies or search orders which have not yet been executed may need to be, may be information which needs to be the judge may need to be informed of. But you may feel, well, how do I present this to the judge? Because I've got to produce a note that needs to be served on the other side after the hearing, and the order will go out as well. That may tip off that respondent and scupper any plans you may have in respect of execution of other orders. In that situation, it's important that you draft your evidence in a very careful manner. Maybe it's important just to inform the court of the fact that there are other applications or other orders in progress and nothing more. Also, what's important here is to liaise with counsel and really work together as a team, because the counsel needs to be aware of what can and cannot be said.
Okay. So the fifth point is don't make assumptions. So for example, just because you think the respondent has taken one particular class of document, don't assume that they've taken another. Judges don't like that. They like you to be quite clear and say, well, we know he's taken this particular class of document, so what we're asking for in the order is that he discloses that class of document and anything linked to it. So it's not just going out and making that wholesale assumption, but it's being careful in how you word it. There's a particular case about a freezing injunction where the applicant was looking for a worldwide freezing order, and they were aware that the respondent had a account in Russia, I think, at one point. That account had since been closed, and the argument that was put forward is, well, that money must be somewhere. It must be in property, or it must be in other assets. And the judge said, well, no, I'm not going to grant the freezing order on some assumption that it's somewhere. Come back and tell me where you think it is. So judges, whilst they've got a discretion, then they're not going to exercise it widely just because of how draconian these orders are. So just make sure you've done as much research as you possibly can in the time available to you, and just be tight and clear in what you're asking for. And the last point is consider your evidence against each respondent individually. So you might, as I say, in the restraint of trade case, you might have your employee and you might have their new employer or their new business. The particular things that you're asking against each individual might be very different. So your evidence needs to be presented differently. In respect of the employee, you can say, well, we have evidence to demonstrate that he has taken XYZ information. So we're going to prohibit him from passing that on. What we're going to ask the new company to do is prohibit using any information they've had. So it's slightly different and you're asking for slightly different things in your order. So make sure that comes across both in your order and in your evidence, really. Don't just throw everything in and hope that the judge can pull the two things apart, or will be willing to give you any a blanket order in respect of both parties. So that draws our whistle-stop tour of injunctions to a close. The webinars can be viewed on the St Philip's YouTube channel. And if you've got any questions, then mine and Raghav's email addresses are on the screen at the moment. Feel free to email us. We'll be happy to answer any queries you have. I'm just going to stop sharing the screen and just see if anything has popped up quickly now. We have run over slightly, and I apologise for that, and for the technical difficulties that we've had. But thank you so much for joining us this morning, and we hope you enjoy the rest of the day.